Welcome to this module. Here we get to know our customer. This is most important because in terms of the FIC Act, it is one of our duties. According to Section 21, accountable institutions cannot enter into a business relationship or any arrangement between a client and an institution for the purpose of concluding transactions on a regular basis or conclude a single transaction with the client unless they've taken the prescribed steps which identify and verify that client, or if the client is acting on behalf of another client to establish and verify the identity of that other person and the client's authority to act on that other person's behalf. The same requirements apply if another person is acting on behalf of the client. Section 22 creates a duty to keep and maintain records of all transactions when conducting relationships. So your responsibility is that you have to identify this client. How would you do that? Well, you have to find out, are you dealing with a personal, individual customer or a business customer? You then have to work out what their potential risk rating is. And this will help you to decide which category they fall under in regards to the Know Your Client or client identification and verification requirements. And that in turn is a guide to the documentation and information you'll need from them to be able to complete the client due diligence requirements. There are three stages of client identification verification, or Know Your Client. Identification, verification, and profiling. Let us delve deeper into this. Personal customers can be divided into four groups. Your first group is a group that actually resides in South Africa, and they may be adult individuals who are domestic citizens or foreign nationals. Your second group are those that do not live in South Africa. Your third group are those that are citizens of South Africa, but they temporarily are residing overseas. And your last group are those who do not have legal capacity, such as minors. Business customers have a lot of groups which they can belong to. They could be, for instance, partnerships, professional partnerships. They could be closed corporations or be on a stock exchange, such as the Johannesburg Stock Exchange, and they're called listed companies at that point. They can also be foreign companies. The trade name and company of incorporation is required during the identification process in this case. They can be trusts, and these refer to inter vivos trusts, trusts established and in operation while the founder is still alive. They could also be other legal persons, such as a social club, a stokvlei, a burial society, or government organizations. Identification is when the information about the customer is gathered, such as the green barcoded ID document and current physical addresses. The purpose is to identify them, who they are, what they do, and what they do for a living. If you have all these details, you will be in a position to assist if an investigation is launched against a client. The second step is to verify those details. You have to verify the details are authentic by comparing the identification details given by the customer to the details on the original green barcoded ID document, passport or driver's license. This means you need to know what an ID number means. So let's see what makes up an ID number. The first 6 numbers are the birth date of the person in year, month, date format. Next 4 are gender, and that means 5,000 above is male and below 5,000 would be female. The next number is the country ID. 0 is South Africa and 1 is not. The second last number used to be a racial identifier but now means nothing. Profiling has to take place when a new account is opened. The profile should be used to monitor future account activity and entails the following: the source of funds that will be used in the customer's transactions, such as an inheritance or the proceeds of an investment. The source of income, which is different from the source of funds, which could be a monthly salary for personal customers or the income from a daily operation of a business. And the source of wealth for high investment amounts and high-risk clients. The type of activity expected on the account, which can be regular salary payments or cash deposits from the business. And this information must be recorded. When dealing with customers in the identification and verification stages, you need to enforce certain identification standards. You need to verify a customer's physical address, for instance. Information regarding the physical residence of a customer may often be important for law enforcement processes, such as where a matter has been reported to the authorities and a customer needs to be located. Specific documents per category of customer are used to confirm the customer's physical address. They are acceptable because they are regarded as reasonable proof of residential business addresses and are in many cases based on the posting of a document or letter to the residential address of the customer. There are other documents you can use to verify a person's address. Recent SARS tax returns, such as the IRP5 or official correspondence reflecting the SARS tax reference number, full name and residential address of the person, is allowed. Also, a payslip that's less than 3 months old, reflecting the name and address of the person. Let's summarize what the face-to-face customer needs. A copy of a green ID document, which must be clear, legible, and the face of the customer clearly noticeable. You can also accept a passport or driver's license, but only if the customer has a valid reason. The only acceptable and valid reason is if the original green ID document is lost or stolen, and they have proof they've applied for a new ID document. This reason needs to be recorded on the customer's file. A valid passport for a foreigner is acceptable. You are required to review the customer's original identity document in his or her presence. You then make a copy of the ID and stamp it or sign with your details on it, stating the true copy of the original was viewed by you, confirming a true likeness. True likeness means you've compared the customer's face to the photograph in the ID and have found the photograph to be a true likeness. In other words, the customer is a black male with a mole. The photograph in the ID must look like the man you are dealing with. Sometimes you cannot have a face-to-face with your customer, and it's permissible in the following circumstances to have this. If your customer is legally incapacitated due to a disability or injury and is unable to come in for face-to-face identification, you can use this as a reason, but this must be noted. A minor who's younger than 18 years, and again this must be noted. And finally, a related party of a business customer in circumstances where it's not feasible or practical to be identified face-to-face. However, there is a proviso with that. If the related party is an authorized signatory on the account, he or she must be identified face-to-face. For example, of a related party, a closed corporation has 10 members. One of the members may come in with the original certified identity card documents and the information of all members. Often for KYC CIV purposes, we get certified documents, and these must contain the Commissioner of Oath's full name and surname, designation, physical address, date and signature. This can appear either as a stamp or be handwritten, but handwritten information must be clear, and you must be able to read it. The Commissioner should record on the copy that is certified a true copy of the original. In most instances, the document is certified either by a Commissioner of Oaths, the South African Police, an attorney or a notary public. But if you're not sure about the document, then get guidance from the Group Money Laundering Control Officer. Occasionally, you get documents that are delivered to you by hand, mail, messenger, courier, or by fax. When you get a fax received, you have to take additional steps and confirm the documents are in fact those of the client in question. Sometimes you have to deal with related parties, such as third-party signatories and secondary cardholders. You must identify all third-party and secondary cardholders as per the mandatory information for individual customers. This means you have to obtain these customers' ID, residential address and contract details, but no verification is required for the contact details. Joint account holders, where this is permissible, must be identified and verified like all personal customers. You'll have to identify the category of customer before requesting the KYC CIV documents from them. Persons who act on behalf of individual clients, for instance, court-appointed curators or power of attorney holders, you must identify and verify these types of related parties as you would a personal customer. The person acting on behalf of an individual must give you written confirmation that they have the authority to act on behalf of the individual customer, such as a valid power of attorney document. A closed corporation is defined as an entity that is made up of a maximum of 10 natural person members that conduct their business with the intention of making a profit. In terms of the Companies Act of 2008, closed corporations will no longer be registered on or after the 1st of May 2011. Companies are also no longer permitted to convert to closed corporations on or after the 1st of May 2011. Existing closed corporations will continue to exist indefinitely, and existing documentation relating to CCs will continue to remain acceptable. So what are KYC, CIV requirements for CCs? Well, you need to have the certification of incorporation, that's the CK1 form. You need to have an amended founding statement or CK2 form, and you need to have the document issued by the CIPC. You also have to have proof of operating address. When a closed corporation converts to another company type, there are other documents that are required. This includes a COR 18.1 or application to convert a closed corporation. You would have to have a COR 18.3 registration certificate. The KYC CIV requirements for listed companies can be obtained from a listed company's website or the stock exchange's website and needs to be gathered on the listed company. Listed companies are public companies listed on the stock exchange, and listed companies are not listed on the stock exchange, and shareholders don't extend to the general public. The KYC CIV requirements for listed companies include the following. You have to have all related parties identified and verified as per the mandatory information applicable to the category of customer. You have to have contact details obtained for all related parties. And you do not need to have any residential address verifications required, nor is there any profiling information required for the related parties. KYC CIV requirements for unlisted companies include documentation of registered names and registration numbers, trade names, physical business address details, the registered address and tax details. The certificate of incorporation bearing the stamp of the Register of Companies or the equivalent documentation issued by the company register may be used. If the customer is a foreign company, obtain the foreign incorporation documents reflecting the name, company registration number and address. The KYC CIV requirements for unlisted companies would include the mandatory information as per the category of customer. This could be an individual or it could be a trust. The contact details must be obtained for all related parties, and no residential address verifications are required, nor is any profiling information required for the various parties. Partnerships are not normally incorporated companies and can be defined as an agreement where parties agree to cooperate to advance their mutual interests. A partnership needs to supply a partnership agreement if one exists, or a written confirmation letter by the partners if no partnership agreement exists. They also need to supply information as partners that are per the mandatory information applicable to the category of customer. Professional partnerships are a little bit different. Here, because the people are professionals, they are not allowed to form a company and have to form associate partnerships. This could be an attorney, notary, or conveyancer, a public accountant or auditor, a professional engineer, a quantity surveyor, a pharmacist, a stockbroker, an architect, or a medical practitioner, dentist, or psychologist. KYC or CIV requirements for partnerships are a little bit different. They require every partner, whether it's in commandite or an anonymous partnership or any similar partnership, must be identified as per the mandatory information for the category of customer within which they fall. Ask partners to state their shareholding in the partnership so that you can determine whether there are any undisclosed partners. This is most important. The authorized signatories in the partnership have to be identified as per the mandatory information for individual customers. Further requirements for partnerships include the person who exercises executive control must be identified. The person who acts on behalf of the partnership must be identified and verified. And that's everybody who acts on behalf of a partnership, as per the mandatory information for individual customers. You have to obtain written confirmation that the person has the authority to act on behalf of the partnership. KYC or CRV requirements for trusts depend on the type of trust. The inter vivos trust is a trust that's established and in operation while the founder is still alive. These trusts are normally formed for people who need to have some kind of protection of their assets. A testamentary trust is formed in terms of a will. Trusts that are excluded from the KYC CRV requirements are those that are established by virtue of a testamentary writing, that is a will. Normally a trust such as this is for a minor, by virtue of a court order, that could be for somebody who's no longer of sound mind and body, for persons under curatorship, and by the trustees of a retirement fund regarding benefits payable to the beneficiaries of that retirement fund. KYC CRV requirements for trusts are quite onerous because trusts are loosely controlled in South Africa and can be used for tax evasion and money laundering. Your KYC CRV requirements include your name and registration number, the list of named beneficiaries. This can be found in the trust deed or other founding document. The list of authorized trustees. They get a letter of authority issued by the Master's Office, the address of the Master's Office where the trust is registered, and the tax details. The following related parties must also be identified as per the mandatory information for this category of customer: the trustee, the beneficiaries, the authorized signatories, the founder, settlor, or donor. They could be one and the same person, and any persons who act on behalf of the trust. You would also have to ask for the authority to act on behalf of the trust, which is your trustee letter. Foreign companies require an incorporated name. Now, an incorporated name can be obtained by getting the documents from the country of origin, bearing the name, incorporation number, and business address there. The incorporation number, the incorporation address then would all be obtained by this means. The trading name in the country where it conducts business. Now, trading names can be verified by the most practical means. That could be on the net, or it could be by, again, the documentation that the person gives you. The trading name in South Africa, the operating address, and the income tax number. Income tax and VAT registration numbers can be verified by checking against any document issued by SARS that has the business details and tax numbers. The VAT number if issued, and full names, date of birth, residential address, contact particulars, and identity numbers of the manager of the business, as well as each person who can transact on behalf of the business. The full details as above of any natural person, legal person, partnership or trust who holds more than 25% of voting rights in the company. There are other organizations which are considered legal persons, and these include but aren't limited to organizations such as stokvels, burial societies, universities, embassies, non-government organizations, churches, government organizations, municipalities, and schools. The Act has regulations detailing steps to take when dealing with other legal persons, but your first step should always be to establish the legal nature of the entity that you deal with. If it's registered as a CC or a company, whether it's unlisted or listed, it needs to be dealt with as such. If it does not fall into any category, then it should be treated as an other legal person, and the following documents are required: the name, the address, the legal forms, the income tax registration number if one was issued, and the full names, dates of birth, residential address, contact particulars, and identity numbers of each person who can transact on behalf of the entity. Sure, Aren't you tired? I know I am. This is such a long section and details in so much information that you have to remember. Companies are supposed to have policies and procedures in place to ensure that you capture this information. However, that does not excuse you from fulfilling your obligations in terms of this Act. Section 21 of FICA establishes money laundering control measures which relate to the identification of clients in terms of the Know Your Client principle. Section 46 creates the offence if you fail to identify the clients. And the consequences of not complying are severe and include a jail sentence of up to 15 years or a 100 million rand fine. If you're registered under another act such as FACE, you can also be debarred. It simply is not worth taking the risk. So know your FICA, and I'll see you on the next module.